It's 9:05, so why don't we get started? So first, I think, Sabinda, if you could tell us a little bit about FINYE, since this is, an FINYE event.
FINYE is Federation of International Youth Entrepreneurs.
Mhm.
Our goal is to promote youth and entrepreneurship all for the Nepalese diaspora. So we've been practicing this for last 1 year, last 2 years. So basically, we want to promote youth and entrepreneurship for the Nepalese diaspora in the US. So we like to provide one platform for all the industries. We don't want to limit any industries, banking, real estate, tourism, or any IT information technology, all of that. So basically, फिने भन्नाले नेपालीमा पनि म उ गर्छु हाम्रो ओभरअल नेप्लिज डायस्पोरालाई चाहिँ युथ एन्ड एन्टरप्रेन्योरसिपमा चाहिँ अलिकति प्रमोट गर्ने हो जस्तो एक्जाम्पल नेपालमा एफएनसिसिआई भन्ने अर्गनाइजेसन छ उसले के गर्छ भन्दा नेप्लिज डायस्पोरालाई कसरी प्रस्परस बनाउने भनेर चाहिँ एउटा प्र्याक्टिस गर्छ त्यस्तै फिनेले चाहिँ यो लास्ट 2 इयर्समा चाहिँ हामीले प्र्याक्टिस गरिरहेको छौँ हाम्रो ग्लोबल एउटा संस्था हो यो चाहिँ इट्स अ ग्लोबल अर्गनाइजेसन वी ह्याड अ ग्लोबल इभेन्ट इन हङकङ म आफै पनि चाहिँ त्यो लास्ट नोभेम्बरमा चाहिँ हाम्रो इभेन्ट भएको थियो आई वाज इन हङकङ फर 2 days एन्ड जापान फर 3 days त्यही कन्सेप्टलाई चाहिँ ओभरअल नेपालीहरूलाई कसरी चाहिँ अन्टरप्रेन्योरसिपमा प्रमोट गर्ने भन्ने एउटा आइडियालाई चाहिँ हामीले ओभरअल द अल ओभर द युएसमा एउटा चाहिँ यो संस्थाकोबाट थ्रुबाट चाहिँ प्रमोट गर्न खोजिया हो होइन मलाई कस्तो लाग्छ पर्सनली मेरो आफ्नो ओपिनियन भन्दाखेरि हाम्रो ओभरअल अरू अरू धेरै कुराहरू अहिले भइरहेछ हाम्रो ओभरअल डायस्पोराको नेपालीको नेप्लिज डायस्पोराको चाहिँ मेन च्यालेन्ज भनेको चाहिँ अम, अशिक्षा र गरिबी हो क्या मेन चाहिँ सो अरू कुराहरू भनेको सेकेन्ड प्रायोरिटी जस्तो नेपालको केसमा कुरा गर्दाखेरि अब ओभरअल नेपाली डायस्पोरा नेपाल नै भोलि सिङ्गापुर भयो भनेदेखि अथवा चाहिँ भोलि स्विजरल्यान्ड भयो भनेदेखि त्यो बाँकी 80% चाहिँ जुन च्यालेन्जेसहरू आफै सल्भ हुन्छ सो बेसिकली इट्स अ प्रस्परस कम्युनिटी कसरी बनाउने भन्ने खालको एउटा चाहिँ प्र्याक्टिस हो सो बेसिकली अर्को वेमा भन्दाखेरि चाहिँ फिने इज मोर लाइक Chamber of Commerce. So it not only focus on one state, but it focus all over the US and also all globally.
All right, Sabinda, thank you. So Prab, do you want to say a little bit about Staggered? And then I can introduce Roshan.
Sure, happy to. I'll be very brief. Namaste, everyone. Good evening. Thanks for joining. I know it's a work day, and a lot of us have other commitments. So good to see all of you here. Briefly, staggered equity. Reshma and I started this in Charlotte, North Carolina, and it's been a few years. We started by initially investing in real estates. Our vision and mission is like twofold. एउटा चाहिँ हाम्रो primarily community to allow or to bring access to our community on investment opportunities. And अर्को चाहिँ on the other side to bring like opportunities, whether it's startups or real estate deals, so they can be funded. And so we play a role of a bridge between investment opportunities and investors. And in that process, we believe that particularly हाम्रो community is not really of a younger diaspora भएको हुनाले not really familiar with a lot of things that goes on in the financial and investment world. And hence the program like this, where there are legal, there are accounting, there are other things. So Staggered prides itself in having a very vast network of professionals. And we want to, grow, learn together with our community, and also bring the community to a level where they're all educated and are making, good investments, and hopefully, raise the whole community through investment facilitation. So I'll stop there, and then if there's any question, staggered equity in particular, I'm happy to take it. But Roshan Ji, sorry I missed meeting you in Chicago. Great to have you on the call here. Thank you.
Thank you, Roshanda, for joining us today, all dressed up. It's a treat to have you. So a little bit about Roshanda. He is expert in intellectual property. The reason I have handpicked and choose few people to be here today, like Rosadi, is because, we want to promote entrepreneurship and in Nepali community. And she is CEO and founder of an AI company. There's few others here who is developing their own softwares. They're working on few other businesses and all. And we truly believe that Roshan Dai will be able to help them. A little bit about him. He is a scientist turned attorney, also holds a PhD. He's alumni of North Carolina Chapel Hill, and now he resides in Chicago. He's father to two kids, and more than anything, he is a very kind, gentle, and he's full of humility. So welcome, Roshanda, to the webinar today.
Oh, thank you. That was more than what my kids will say about me. But thank you. I really appreciate the introduction. Even though we have a lot of Nepalese people here, I'm going to give this in English because I think there are a few international attendees as well. So if you don't mind, I'll be speaking in English today. And today's topic is very simple to me. I do this every day in and out, but this seems to trip a lot of new entrepreneurs, startups, and sometimes even seasoned people. So I wanted to make sure that, we lay out the basics. What's the basics? What to do, what not to do. And I've got some cases that I will share with you today. So just before I do that, I want to just briefly talk about my firm. I live here in Chicago. I work in a firm called Taft. We have offices around the country now. And, we've got about 1,000 lawyers. So what we call ourselves is a full service law firm where we can help with everything, right? Business, finance, healthcare, intellectual property, labor and employment, real estate, taxes, right? We do everything. So a one-stop shop for the client. That's what we're built for. And our firm, obviously, is humble, but also we toot our own horn sometimes. It's like our clients have recognized us, and we've been recognized in the industry as leaders. And particularly, there are 100 lawyers, IP lawyers, in my firm, and 50 of them are called registered patent attorneys. To practice patent law, you have to take an additional license from the United States Patent Office. So that's about 100 lawyers to help protect intellectual property for our clients. So this is it. So with that in the background, I want to just first start with what is property, right? Everybody knows real estate. We have our land, we have our buildings, right? And we also know personal properties. Like, for example, for a little kid, it might be a toy. For a scientist, it might be a computer, right? Your furniture, jewelry. These would be what we call personal property. And then there is intellectual property, right? What is that? That's information, technology, all the processes that you have, any kind of new formulas you have as a chemist, right? And the most important things are like brands, logos, designs. And what about the photos, the software codes, if the music you write? These are all intellectual property. So how do these categorize, right? So broadly speaking, there's the patents, trademarks, copyright, trade secrets, and then the new wild west is artificial intelligence. So I'll be walking through each one of these now. So first one is, what is patent? Now that is exactly where I make a living. I have a patent myself, 2 patents. I'm an inventor before I was a lawyer. So I help people protect their intellectual ideas, right? So what is patent is, it's a right given by the government, and it's government throughout all the countries, not just United States, is that you tell us what you have invented. You tell us your idea and how you did it, and we will give you for a limited time some monopoly on it. So during that time period, nobody can use it, nobody can make it, nobody can sell it without your permission, of course, right? So what is a patent? Now, patent is an idea, and it has to be novel and very new, and it has to be non-obvious. I'll give you a basic example. Let's say there is a chair, right? Somebody invents a chair. You can sit on it. It's great. You can sit on it. It's fantastic. You can even have a back support. Now somebody else comes in and I say, well, I'm going to make a chair with just 3 legs, right? Now that is definitely new. There's never been a chair with 3 legs. Usually there's only 4 legs. But if somebody comes and says, I'm going to make a chair with 3 legs, chances are it's new, but it is not not non-obvious, right? It is like an obvious variation, So, but what if somebody comes and says, I'm going to make a chair with two legs, and to balance it, I'm going to use some gyroscope, right? Now, that is an idea worth exploring, right? And if I can write a software code for it to just automatically turn around and go get me some water when needed, that is even more fantastic, right? For the AI people, these are ideas worth patenting. Okay, so how do you patent an idea? So you write it down, basically. You tell the world what you have invented and how you did it and what is the scope of it. And then basically you run to the patent office. It's literally a race. For example, let's say during the COVID time, a lot of people were making COVID vaccines, right? But the people who went first got patents on it, right? There's still some dispute with Pfizer and a couple other drug companies about who has the rights, right? So the first to file always wins that race, right? And then it generally takes about 1 to 4 years, and sometimes even longer to get that patent allowed. And in return, you get 20 years of monopoly on it. So your ideas is protected by a patent for 20 years. There's a hand raised, but can I just, you want to ask a question?
Yes, I have a question. Can I ask, what's your story? Like, I'd like to know more about your background and what led you to become an attorney.
Oh,
Right. Uh, so can I do that at the end? Okay.
Yes.
All right. I'll be happy to just sit around and have a discussion on it as well. But let me go through my main focus today, right? So patent registration gives you 20 years of monopoly, right? So the way I like to explain things is the difference between a real property and a patent law is it's essentially like a property, right? If you look at this as a Zillow, you look at houses, you have a fence, right? You put a fence around your house, and then that's your property, right? You can build whatever you want inside it. You can build a swimming pool. Look, a lot of people have trampoline. I've got a basketball court, and sometimes the fence breaks down, and if your neighbor tries to build a fence in your property, then obviously that's infringing, and then you have a problem. And a lot of times people fight over the boundaries, right? Countries fight over their boundaries. That is real property. Now, intellectual property and mostly patents is not as clear cut as this. It is very intertwined, and I like to explain this with this abstract drawing. Like somebody might have intellectual property that has these ideas in it, and almost always there's always some overlap, right? Now, most of the times nobody fights over these things, but sometimes those little overlaps can make a lot of difference. For example, if you look at the history between Apple and Samsung, they've been fighting over patents uh, as soon as the smartphones came up, right? And most of the time, their fights are at the fringes. It's not like who invented the smartphone, but who invented the little button that's on the side that does something, right? So that is intellectual property and the difference between a real property and intellectual property. So why patent your ideas, right? So obviously you want to protect your ideas. That's the first thing. But then it also attracts investors and funding, right? If you look at Shark Tank, whenever you pitch an idea, they say, is it protected by a patent, right? That's the first questions most investors ask. Because if I invest money and somebody else can just duplicate it the next day, what's the point, right? And it also prevents your competitors from filing a patent, and it strengthens your position in the marketplace. It obviously deters free riders, right? And you can license your patent. Sometimes you don't even have to use it yourself. And some people get a lot of money through licensing, right? Or cross-licensing. And it can also be used defensively. So for example, you have a company, you've got an idea, you have a patent, and usually whenever many people in the same field, sometimes they get upset, they try to sue you. Okay, you're infringing my patents, what they will say. And the way you use your defensive patent is, almost always it's in the same field. So you can cross sue, right? You can counter sue is what we call. That's what's happened between Samsung and Apple. And then what happens is that now you're not just playing defense, so getting sued, but you can also sue. And the result, what happens is almost most of the time people cross license and everybody's happy, right? Now you've got a little expanded area that you can work on. The competitors is also happy because they can also expand a little bit. They can give you money. You can give them a little bit of money, right? And it's also, if you have a lot of patents, people bank their entire things on patent portfolio. So it's a really good corporate image as well. So that is patent. The next topic, obviously, is what is a trademark, right? Now, trademark, I would say, is more valuable than a patent. And I'll tell you why in a little bit. Is basically it is a source of origin of goods. That's what it describes. Okay, where is this coming from? You can patent color, you can patent sound, right? The Microsoft's opening sound that comes up, right? That you can patent. Um, you can patent scents, words, right? You can even packages. You can patent uniforms. Those are called trade dresses. And sometimes you can even patent, trademark store designs. Like, for example, that is why you see uh, McDonald's store is almost similar wherever you go, right? That's their trademark, right? And then nobody else can copy that. So as I said, you can do a color combination of colors, like with the John Deere tractors, right? Green and yellow, very prominent, right? The design of a bottle, like the Coca-Cola bottle, and words and also logos can also be trademarked. So again, just like patent, it has to be unique, right? It has to be very distinct, and it has to be different from pre-existing brands. And I'll tell you why in a little bit, right? Sometimes some people come close. Sometimes the spelling is different, right? But that sometimes creates a problem. But what does trademark do? They generate your goodwill, right? They develop your brand, and it builds trust with your customers. That's what trademarks are good for, right? So what do you use to come up with a name for your company, name of your product, right? And what can get more protection and what can get less protection, right? For example, you cannot protect water, right? You cannot protect computer because those are generic words, right? And Q-tip used to be a patent, trademark, sorry, and it's still a trademark, but because now everybody uses the word Q-tip so commonly, and even the danger now is Google is also being used so commonly because everybody said just Google it, right? Instead of saying Google search it. So when it becomes very generic, your strength of your trademark is rather on the weak side, right? And as you progress to the right, you see the next is a descriptive, like for example, American Airlines. That is, that, okay, it's an airlines from United States. That's pretty easy. It's a little more strong, right? And then the next one, what we call suggestive, Burger King. Now, obviously, there's no king in there, but the customer can guess that, okay, this place serves burger and maybe it's really good because that's why he calls himself the king, right? So that's suggestive. And then there is just arbitrary things, which is one of the most valuable patents, like Starbucks, right? Starbucks has nothing to do with coffee or what it sells, but people know when I say Starbucks, it relates to coffee because they've invested so much in their brands and advertising. That's the source of a good coffee is what people associate Starbucks with. And maybe not everybody can agree that it's the best coffee in the world, right? And then there is just fanciful thing that has nothing related, but it's just unique. Like for example, Yahoo, right? Google and Adidas, right? These words have no meaning, no connections, and then it's just and then beautiful design, and then people love it. So again, it is the trademark is not the product itself. That is why a lot of people with trademark cringe when people start using their trademark like a product or a verb, right? For example, whenever you have a Google, people hear you say, let's Google it. They start getting worried because when everybody says let's Google it, right? It dilutes their trademark, and it starts becoming more generic. So the correct way to use a trademark is instead of saying, may I have a Kleenex? You have to say, may I have a Kleenex tissue, right? Because it's not the product itself, it's the source identifier. That tissue is from Kleenex, right? And what is this little sign TM and how is that different from R that we have, right? So basically what happens is that as you get rights to that mark as soon as you start using it in commerce. You don't have to register it. For example, I can open a shop here that says Himalayan restaurant. I have trademark on it, except if there was somebody else who's already opened a Himalayan restaurant here, right? So that's the first one to use it always gets priority. But why register it then? But if you federally register it, then in the United States, you can use that mark throughout the country. Now, instead of just being local to Chicago or Charlotte, you can use it everywhere else, right? That's the power of federal registration. Then you can also use the word R on it, right? Registered, right? And then this is why trademark is so valuable, is because it has no time limit. Because Coca-Cola mark has been used for more than 100 years now, right? BMW, very powerful brands. And they never expire as long as you use it in commerce. Patents expire, right? And we'll see later copyrights expire too. But trademarks don't expire. And a lot of brand value, people put a lot of brand value in there. In their trademarks, right? And to a certain extent, these athletes, they have their name and likeness being used. That's essentially like a trademark too, right? Because that has value. You know, if Tiger Woods advertises something, it has more value than I advertise something, right? So that's brand awareness. So, so coming back, the key importance of registration with the USPTO is that you get nationwide rights. And one of the nice things that happens is that when you have to sue somebody for trademark infringement, you get pretty substantial damages on it, right? Statutorily, you get something, but you don't get that until you you have a copy or a trademark on it. And obviously, when you put the R symbol on it, it's generally supposed to deter other people from using it. Basically, you are telling that, hey, I've used this mark and this mark is registered, don't use it. Essentially, that is what you're saying, okay? So coming back to it, there's one very famous case. So the case is Microsoft v. guy named Mike Rowe, okay? There was a 17-year-old boy in Canada, and he's a software geek, so he opened up a domain name called Mike Rowe Soft, right, on his name. He wasn't trying to steal Microsoft ideas, Microsoft. But then Microsoft sued him for trademark infringement, right? So because it sounded so similar, and sometimes it happens all the time because you change one letter in the word and it becomes you try to pass. One time I thought I was buying a SanDisk USB drive from Amazon, and it was a little cheap. And then when I got it, I realized it was not SanDisk, it was Sam Disk, right? So that's obviously trademark coming very close, right? And so that is what these trademark is supposed to deter. So this case had a happy ending. So Microsoft sued him aggressively and then just went very heavily after this 17-year-old, I would say kid, right? He's not even an adult yet. And this generated a tremendous backlash against Microsoft for being aggressive like a bully. And there was a lot of online support for this kid named Rowe. So the outcome is obviously they settled immediately out of court. Supposedly, Microsoft settled it for an Xbox and some Microsoft products, but almost always there's always some money involved as well. So that is what you can do. You can leverage your trademark and protect it, right? So the next one is copyright, right? So copyright is amazing because as soon as you write something on a piece of paper, carve something on a piece of wood, type a code in a computer and save it, that is your copyright. Nobody else can use it, right? What you can do is now you can also register that with the Copyright Office, and then everybody knows that it is yours, right? And then you can put the word or the symbol C around it. Right? But it has to be in a tangible medium. You cannot say, I've got a great idea about this product, and I've got the code written, everything on my head. No, that cannot be copyrighted. It has to be on a tangible medium, right? And it has to, again, that's what it means to cover. It cannot cover ideas, but there is a time limit on when it is protected. It's the lifetime of the author plus 70 years. Unless there's a certain loopholes, like for example, like Winnie the Pooh, that's copyrighted. Those storybooks are copyrighted. Mickey Mouse storybooks are copyrighted. And Mickey Mouse, Walt Disney died many, many years ago, and plus 70, it's more than 70 years ago, right? But if a company owns it, they can continue a little bit longer, I think. And I don't know if you know this, but you could technically not sing the song Happy Birthday on a public space because that was copyrighted, and that copyright expired very recently. And that's why now you can start hearing in movies, people can actually now sing Happy Birthday without paying some family a lot of money. Okay. So again, it belongs mostly to the creator. So whoever creates it is and that authorship is again automatic, except when you're an employee, right? And you have a contract that says, I'm going to pay you, you will write this code for me. Then even though the coder wrote the code, it actually belongs to the company. And that is why a lot of companies get into trouble, right? If you don't have a good contract with a consultant that comes in and does a tremendous amount of work for you, or the consultant goes and does tremendous amount of work and the company says, hey, that is mine, right? So that is why there has to be very, very good contracts, good understanding of who owns that copyright. If I've paid you to write something, then even if there's no contract, then it belongs to me and not you, even though you created it, right? So again, why register it with the US, the Copyright Office? You need to register it to bring a federal lawsuit, right? It strengthens enforcement claims. And there's a certain kind of damages you can get. For example, for songs, I think you can get damages for $5,000 per song per play, right? If you played one time, there's a penalty of $5,000. So it's pretty substantial. So there's a lot of value in registering your copyright. So what cannot be copyrighted, right? Anything that's in the public domain, like this NASA has a James Webb Telescope, has produced beautiful, beautiful images of the deep space, right? But that you cannot copyright that, even though it's a work, somebody actually took a photo of it because it belongs to us, the taxpayers, because it's the US government work, right? You cannot, again, patent ideas, anything in the public domain. You cannot patent facts, right? You cannot say that I'm going to copyright the news. You can copyright the news article, something saying about the news, but the news is not copyrightable, right? And generally, you cannot even copyright titles and slogans as well. So, and there's this element called fair use. So sometimes, you will see late night TV shows, they make fun of things that other people have said, right? Other people have written. They make parody. Newspapers, they comment on it. They say, based on the report in Wall Street Journal, which said blah, 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 right? When you say that, that's obviously not copying it, but you're transforming it. You're providing context. So that is essentially, and that is permitted. And sometimes I can go online and I can say, well, who's playing? The Celtics played today and they won, right? I can say that, but I cannot broadcast the entire show. But maybe I can broadcast 2 seconds of it and so, hey, look, the Celtics were playing today. I can say that, and that would be a fair use, right? And usually, and you will see this in academic research. Most people cite other people's work, right? Because everybody stands on somebody else that have come before them. So all these scholarly articles, when you cite it, and even if you use parts of it, that's published somewhere, that's considered fair use, right? So copyright infringement is one thing. There is just strict liability, which means that if you do it, whether you did it intentionally, non-intentionally, you'll get sued and the other side will win, right? The famous example is this Blurred Lines songs by Robin Thicke and Pharrell Williams. So Marvin Gaye's estate would actually produce a similar song back in 1977, sued them, and they actually won. Robin Thicke had to pay $5 million to the estate and 50% of royalty for every time that song plays from now on. Okay. So there's a big lawsuit about this poster of Obama. This poster was started with an AP photo. Somebody took this artist named Shepard Fairey. He created this iconic image, right, from a photo that's from an AP photo, right? And even though it looks a little bit different, right? But AP claimed that it was a copyright infringement. Right, and Fary's defense was, well, this was fair use because look, I transformed it. It's no longer yours. It's an artistic thing, right? We obviously didn't know who was going to win in this case because, again, here the party settled out of court. But the notion here is if it comes close, sometimes it's better to ask for permission than get sued later because that's more expensive, right? And sometimes even political art can also raise red flags. So in the internet age, like there is also the Digital Millennium Copyright Act, right? You saw Napsters, people are stealing music left and right. So there's this new idea, the new law that came about in 1998, and it's been revised several times. It provides protection for online infringement, right? And in that time, people were suing the internet service providers as well. So they were suing Comcast for supporting this infringement. And then the law says now they're protected, that they provide safe harbor for service providers, right? And then it also makes it illegal. So sometimes, video games and even softwares, they have encryption, right? You cannot see the source code when you use the software, right? If you try to break that, that's again an automatic statutory violation, and you're going to get penalized for it under the federal law, right? And then there's also a provision that if you're a copyright holder and if you're like infringing and putting it on YouTube, you can write to YouTube, say, hey, that's my copyright. Look, this is my registration. You need to take that down. And YouTube is required to take that down. So that is copyright. The next one is secret, right? Trade secret. Now, what is trade secret? It's all financial modeling that you do, technical data, anything that you do not publish, that you keep secret, right? And it has to have some economic value. Some very famous examples are like Coca-Cola's formula is a secret that nobody knows, right? And then sometimes source code, some people publish it as a copyright, like Microsoft source code was published early on, but that created a lot of problems. But now they use technology to protect it. So source code can also be a trade secret. So what is important about trade secret is you have to continue to protect it. So if you give it to one person and say, hey, you can use it, but then if somebody else uses the same thing and you go after him and say, it's my trade secret, then that doesn't work because you did not protect it. You have to have the utmost control, right? You have to have NDAs in place before disclosing it to anybody. You have to have access control. Only people who need it have to have access of it, not every employee in your firm, right? You need to give special training to employees to tell them, make them aware that this is our trade secrets. For example, I just bought a case in which the customer service list, right? You develop a lot of lists. You can buy these online, but when you develop it yourself, that can also be a trade secret because not everybody has it, and it has economic value, right? And I briefly talked to you about enforcement and how do you capitalize trade secret, just like how you capitalize any other IP, right? It gives you competitive advantage. You can license it, like Coca-Cola licenses it all the time. It gives its formula to the bottlers, but they don't know what it is. Right? That also adds a tremendous amount of value to your company. Now, the last one is everybody talks about artificial intelligence, right? It has amazing potential. You can do so many things with deepfake videos to writing essays, poems, songs, whatever. They can do so many things apparently, right? But the problem that comes in is now it's still not clear if you use artificial intelligence to, let's say, develop a cure of cancer. And that's happening a lot, right? Because companies are using it. So who owns that intellectual property? Obviously, for now, the company who paid the AI owns it. But what if at some point AI can become so good that it can just start filing its own patent applications? Can it do that? Probably. It won't, maybe not too distant future, right? It can do that. But that law is, again, it's very, very not clear right now, right? So, and in my profession, a lot of people have, a lot of lawyers have been dinged in the court for plagiarizing. They're using AI to write the papers to submit to the court, And AI obviously is not perfect, so it creates its own cases. So when citing some cases, they cite some random cases, it makes it look real. And when the judge looks at it and there's no such case that exists, then the lawyers get into problems, right? And I'm sure students get into problems for plagiarism, students get into problem for using AI in substantive portions of their work, right? So for companies, how do you protect yourselves? So usually if you use something that was AI, you have to use disclaimers, right? If you're doing something with AI and if your client says, please do not use my data on a public domain, then you cannot use open source AI for those, right? And then, and a lot of companies have also gotten in trouble for generating. Sometimes AI has this built-in bias. What Amazon was finding out is that it was disproportionately rejecting African American applicants in their job application, and they got into trouble for that. So that's essentially all the guidance we have so far because the law has yet to catch up with artificial intelligence. So in summary, I want to just run about what we've learned so far and what is important for your business as you start out, right? If you have no IP strategy, you get into a lot of trouble. So as soon as you do something, let's say before you name a company, right? Do a trademark search, file a trademark for it. If there's a good logo for it, file a trademark for it. If you have ideas like, for example, even instruction manuals, you can copyright them, right? If you have really tangible scientific ideas, you can patent those, right? And some things like source code, you can keep them as trade secrets. Right? Because, and this is very important that you not only do this, but then you have, as the company grows, you bring in consultants, you bring in employees, you have to make sure who owns this IP. It's the company that owns the IP, not the guy who created it, because you're paying these people, right? You have to make that very clear. And if you're a consultant and if you have your own software that you're taking it to your client, you have to make sure that the client cannot claim that now they own that software that you actually built to help the client, right? So you have to really distinguish what is yours and what is mine. So the next one is skipping IP searches, right? You get into a lot of problems for it. So sometimes people are excited, they've got a lot of money coming in, there's a market, there's a rush to market, let's launch it very quickly. They forgot to do due diligence. And then once you start selling, the cat is out of the bag. You can get sued for it. And it is a lot expensive to fix it later than spend that little extra time at the beginning to make sure that you do your due diligence, that nobody else owns it, right? So when you are starting out a new product, what we always recommend is look at what's already out there. And if anybody has trademark, copyright, or patents on it, right? And these are very easy to search. And so that's what you have to understand. If you have a patent, just like when you buy a land, you know exactly what land you're buying and whose land is on the other side, this side, and whose land is on this side. You do the same thing with intellectual property. Who owns this side of the intellectual property and where is the area that I can carve out, right? And also important that as you grow, you monitor your competitors as well because see what they're doing, because sometimes they're coming up with a patent that you don't know, and you're creating or working in the same space. 6 months later, they get their patent and they might come and sue you. So that's why it's very important to monitor your competitors as well. Mistake number 3, innovation without rights. Again, as I've shared with you, you have a company, you have employees, you have consultants, and you have to make sure you know who owns what, right? Employees come in, they write the software. Consultants come in, they bring their own products, right? And there's founders and there's investors. So who owns the intellectual property? These have to be very clearly defined in contracts, expressly written down somewhere to make sure that there's no fight over who owns what, right? This especially becomes problematic is when there is a foundational technology and somebody builds on top of that. Now, who owns this new technology? Does the person who built the foundation or the person who added the value, right? Because there was no discussion at the beginning. So they're very important to do the talking and do the writing, as what we like to say, keep everything in writing, okay? Number 4 is if you fail to enforce your intellectual property, let's say you work very hard, you found a patent and you filed a patent, you got a patent, right? And somebody else starts making the same thing and you do nothing about it. You just watch him, rip you off. And then there's the third guy who comes in and you really don't like this third guy and you say, I'm going to sue you for patent infringement because now you're infringing my idea. Then the courts will say, well, somebody else was already stealing it right in front of your nose. You didn't do anything about it. So now you basically lost that right to the patent because you've given it to the public. That is how the courts look at it. So when you have your patents, when you have your trademark, it is very important to protect it, to enforce it, right? And that is what Microsoft tried to do early on against Microsoft, right? Starbucks does it. Anything that comes similar to Starbucks, BUX, right? BOX, they will come and sue you, whether you're in the coffee industry or not. Right? They will at least send you a cease and desist letter. Right? And what about internationally? Right? So let's say you invent a great idea here, you patent it in the United States, you don't patent it in India and China, then they start copying it there. You have no protection because intellectual property is very territorial, right? It's every country. But there are avenues in which when you file an idea in the United States, whether it is trademark, whether it is patent, there are provisions in which you can use the same patent application and file it in jurisdictions in other countries where you think it might most be abused. That way you get protection in those countries without having to spend additional without having to reinvent the wheels on this. And lastly, right, not budgeting for your IP, right? IP is an investment. You work very hard, you come up with great ideas. And even in Facebook, there's the social networking. If you look at the history, right, Mike Zuckerberg was there and there were these Winklevoss twins and they didn't really know who owned what. They didn't first clarify at the beginning when it was just an idea startup in a dorm room. But suddenly when it became a billion-dollar company, there was a big fight on it, right? And it is very expensive to fix that fight when a lot of money is involved than at the beginning when it is very clear. One of the things that most of us know Guns N' Roses, if you're anybody who's old as me, Axl Rose is the lead singer for that. And one of the very smartest thing he did is that he copyrighted every song and he told all his band members that you guys are my employees and I own the copyright. Okay, I can give you extra money as a bonus, but you do not get rights to the songs. So that he protected his idea that way. All these songs are copyrighted. And again, don't cut corners because let's say you file a patent, let's say you file a trademark, right? And you didn't do a search because search costs money. And then suddenly and then you launch a product and you realize somebody had a trademark already in 8 different states. Then even if you filed a federal trademark, if somebody had local trademarks in 8 different states, you cannot use that trademark in those states. And Apple ran into this problem in Brazil because it trademarked iPhone, so it could use iPhone everywhere else, except in Brazil, you couldn't call it an iPhone because somebody had already trademarked the word iPhone in Brazil. So pitch for myself, talk to me. I can certainly give you some advice on where to get started if you need help. If you need more help, I can certainly walk you through all the trademark, copyright, and patent issues. And that is it.
Thank you very much, Roshan. Because I had to I had too many questions here. I will jump right into it. But before then, as Savinda was saying earlier, and I think Prakasta joined as well. So FINYE is about youth entrepreneurship, and somebody unmuted themselves to ask a question on how did you become an attorney? What is your story? For some, for families that want to study law, what should be their aspiration, or what should they be studying? Which path should they be taking? I guess they wanted to know. Roshan, if you can tell us a little bit about.
Oh, sure, sure. So my path to law school was very different. I was a scientist before I was a lawyer. I was working at Los Alamos National Lab. I was working on hydrogen energy projects, and then we came up with some fantastic ideas, and some of them we were able to patent, right? Obviously, now we don't own the rights to the patent because it was the government property, so the government has those rights. But that gave me an idea that, hey, I can use my scientific skills to practice another career path, right? But maybe you're interested in real estate, right? There's a lot of real estate laws. You could be a real estate attorney. Immigration is very big. A lot of Nepalese people need immigration. A lot of foreign nationals need immigration, even successful ones, right? So that's pretty big, and because the laws is very flat in chaos right now, people are seeking lawyers' advice a lot more than before, right? So in other areas, for deal making, for M&A, for any kind of financing, restructuring, there's always lawyers involved because when you're doing an M&A, we need to figure out who owns what, like how many trucks do you have, how many factories do you have, right? How many contracts, account receivables you have, and how many intellectual properties you have. So, and what is the value of those intellectual property? So you can do so many things as a lawyer, and especially if you have a science background, you already carve yourself a very strong niche because not a lot of lawyers have science background.
Yeah, thank you very much. Yeah, so this is for all, the teenagers and people who are going to college. Just a quick advice or story from Roshan on how he became an attorney from being a scientist. So I'll just read out a few questions here from the chat. Um, okay, so there is Uber, Lyft, and Patao in Nepal. How is IP filed here protected internationally? Is there IP for services like meditation camp, yoga, etc.?
Good question. So the technology, the Uber and Lyft do the same thing, but they have patents, and we may see it that they essentially work in a similar way, in a customer-facing user experience way, but in the back end, the technology might be very different, right? Because Google can do a search, Yahoo can do a search, Bing can do a search, but how they do that search is very different. So, and the other IP issue is the trademark, right? So that's why in Nepal they don't use Uber. There's the third-party site called Patao. And in other countries, I think in Europe, there's Bolt, right? There are different ones. The technology, again, the idea may not have been protectable, but I'm sure there's Uber. If you search for Uber, they have a lot of very narrow patents filed. For example, how to do a cross-border payment, right? For example, I can use my MasterCard or Visa to pay for Uber when I'm in Europe, when I'm in India. How can I make that happen? Like Lyft doesn't have that capability, it looks like, because I think Lyft looks very domestic to me, right? And Patao maybe has very similar IP issues, but I think in Nepal, in Bangladesh, the big protection that you can get is the trademark, which would be more valuable than the actual patent. So does that answer your question? And then is there IP for services like meditation camp? Well, meditation camp is very generic, so you can maybe not a trademark meditation camp, but what about Bikram yoga, right? That is a very specific type. hot power yoga, right? So these are trademarks. So like I said, you cannot trademark water, but you can trademark vitamin water.
Okay, interesting. When is the
Best
best
time
time
to
to?
get a patent attorney involved? After we build an app or software, or when we get started with an idea? I say, usually big companies. When I've worked for big companies, every time, patent attorneys get involved from the outset, right? Development team already has a patent attorney in the team, or somebody with at least some patent knowledge to know what is already out there, because you don't want to invest hundreds of thousands and sometimes even millions of dollars, come up with an app, only to realize that 5 other people have already filed a patent on it and you cannot do anything about it. Then you've lost all that money. So it's a selfish pitch to myself and my work, my services, but get an attorney involved, or if not, at least have the courage to look around. Everybody can do a Google search. First, search to see what is already out there. Um, so so that's the thing. And then because now the race of getting a patent is the race to the patent office. Whoever comes up with the idea gets to patent it first. Now you may be working in an idea for 2 years, right? And I come up with the same idea, or essentially the same, today. And tomorrow I go to the patent office, even though you came up with the idea 2 years ago and you've been working on it to make it perfect. You're not going to get the patent. I'm going to get the patent on it.
Wow.
So sooner the better.
Okay.
Next one, cross-border conflict. For example, their Zuno company has been registered in Nepal. I said there are other firms with the same name or similar trademark, right?
This is a good one for you, Reshma.
Yeah. I wonder who is it from?
I think it's
So that is why it is again, this is very similar to what Apple faced, right? It to keep things under wrap, it secretly filed all these trademark under different subsidiary names. It didn't even use the word Apple, right? Secretly around the world, it went and did it. It was too late in Brazil, so they couldn't do it in Brazil. So there's always these problems that come in. But then sometimes it also depends in what category you file your patent application. Let's say you file it for a fintech company, right? It's a Zuno. And somebody comes up with a Zuno restaurant because my name is Zuno. Chances are you are not going to be able to prevent that Zuno guy from using that name. But if it is a very famous mark, like Microsoft, Starbucks, like Starbucks will come and sue you even if you have like a uh, like a like a clothing company. Shoes, you make shoes called Starbucks, they will come and sue you because those are famous marks and they get more protection. So what happens if there's Zuno.co that's registered in Nepal, US, and there's the Zuno.com.au. Well, it depends who came with the name first, right? If the Zuno in AU have been established for 8 years, they're in the same fintech industry, then sorry to say, you might have to change your name if you want to practice in Australia. That's what will end up happening, just like how Apple couldn't call itself iPhone in Brazil. There is some
questions.
okay, so those were the substantive questions, and some people thank me, and you're welcome. So somebody's raising their hand. I think it's Ram. Please go ahead.
All right. Good evening, everybody. This is Ram Thapa from Texas. I run a small engineering firm. My specialty is in structural engineer, civil structural engineer. I have patent already, US patent register, but here it is on research process with SMU, this Southern Methodist University. We give their civil engineering department for research. Now my patent is on seismic device to mitigate seismic force, for buildings.
Right.
Most of, we are in Nepal also very seismic zone we have, So my question is, like, some of, you already mentioned about, foreign and USA. USA is no problem, everybody, respect, intellectual, property. But now, my question is, I am trying to make devices for, some devices for building devices in Nepal because of cost effective over there, like a 1/5 or something.
Right.
How I can protect, we know, we have giant in India and China and everything, they have, nature to, like similar, they could do. Yeah. Maybe, I'll send you later on, Mr. Roshan.
Sure. Um,
Detail.
so it depends, right? So there is a uh, there is a protocol in which when you file an application in US, within 36 months of that filing, you can file in a lot of countries, and including Nepal. You can file a patent application in Nepal. Now, Nepal does not have a patent office, but it does have patent registration. So what that means is, let's say you've got a patent in India, you've got a patent in the US, you can go and file that same application in Nepal, and you say, look, but I already have patents from these countries, and sometimes I think the law, at least when I spoke to one Nepali IP attorney, he said that Nepal recognizes those rights, and then you can actually go and enforce those rights. You can do that. But the time to act is very quickly, within 36 months of filing, and you have to file um, through the United States Patent Office. You have to file it around the world.
Yeah, we have already approved here in United States.
Yeah. So you just need to make sure, whoever you filed it with, the patent attorney, they should be able to tell you, is it a WIPO patent? Did you file an international patent application with it that allows you to file in different countries easily using the same application? So to have that conversation with your patent lawyer.
All right. Thank you.
Okay. And
Mr.
just for the
Doctor, we are
record, could
2 minutes
McDonald's
over
sue the
time.
guy who opened McDonald's? Good question. I don't know if you know this. There's Coming to America, right? That movie, and there's this
Yep.
guy who is fighting with McDonald's. His name was McDonald's, and he has same burger company, but his name is McDingles or something like that. Very close, right? And he's complaining that he's always being sued. So for Famous Mark, this might be like a parody, but if you start selling burgers, and if Nepal does not have, McDonald's hasn't registered their trademark in Nepal, then I think it's free game, right? But as with anything else, nobody can really cares about intellectual property unless there's substantial money involved, right? Because it costs a lot of money to enforce some of these patents. Having said that, if you're careless, you said, I'm not going to make any money, but so I'm just going to make an app. And suddenly it becomes very famous, very popular. And now everybody starts copying it. You've essentially lost the right to enforce it because you did not protect it. So never say never, be judgmental. So at least at the beginning, instead of paying anybody, just look for what is already out there and make sure that you're not stepping on somebody's toes.
That's interesting. That is a good one. We are 4 minutes over time. So I don't know if we have time for anything anymore. But Prakasta, did you wanted to say thank you to Roshanda? Is that what it is? Hmm. Okay, I don't think I'm able to unmute him. So I think that is good. Prakash, do you still want to say thank you to Roshanda, or can you hear us?
Of course. Reshma, thank you so much for organizing beautiful events. And at the same time, I think you चाहिँ हाम्रो first चोटि होला यति धेरै participant हुनुभएको. So since when we started this organization 4 years ago, we had such a beautiful dream आज आएर बिस्तारै चाहिँ यो पुरा भएको जस्तो लाग्छ जहाँसम्म लाग्छ आजको यो पार्टिसिपेटले गर्दाखेरि रोशनजी मेरो नाम चाहिँ प्रकाश थापा सो आइ एम द फाउन्डर ग्लोबल भाइस प्रेसिडेन्ट अफ फिने म चाहिँ क्यालिफोर्नियामा हुन्छु
हजुर। नमस्ते।
अनि आजको यो किनभने म प्रत्येक नेपाली अन्टरप्रेनरहरूलाई चाहिँ जहिले पनि एडभाइस गरिरहेकै हुन्छु किनभने धेरै हाम्रो कम्पनीहरूले चाहिँ थाहा हुँदैन इभन द फर इक्जाम्पल रेस्टुरेन्ट ओनरदेखि लिएर अब तपाईँले देख्न सक्नुहुन्छ कति धेरै हिमालयन रेस्टुरेन्टहरू छ राइट होइन अनि तर बेस्ट पार्ट इज लाइक हाम्रो नेपाली दाजुभाइहरूको हार्ट ठुलो छ त्यही भएर यो कपिराइटलाई चाहिँ उहाँहरूले अहिलेसम्म चाहिँ क्लेम गर्न सक्नु भएको छैन तर एट द सेम टाइम अबको न्यू जेनेरेसनले यो कुरा बुझ्नु एकदमै जरुरी छ र आजको यो मिटिङ एकदम फ्रुटफुल भयो त्यसको लागि थ्याङ्क यू सो मच फर यो वन्डरफुल टाइम एट द सेम टाइम आई विल एड इन लिङ्क्डइन लेट्स थ्याङ्क यू
Thank you.
All right, so that's about it. Thank you very much, everyone, for joining. And thank you, Roshanda, for taking the time out, dressing up, and showing up today. It was my pleasure.
This is how I walk around in my house every day.
Yeah, that's your pajamas, I can tell.
Yeah.
All right. Thank you, everyone, for joining. We
Thank
will
you.
talk again in May.
Do you have a question? Somebody looks like somebody's raising their hand. This is Bharati Khadka is the screen name. You're muted.
I don't see it, but somebody did send you a copy of the patent that I will send it, but we are 6 minutes over time and I really have to respect everybody's time.
Okay, thank you very much.
Thank you.
Okay, have a good night.
Good night. Thank
Good
you.
morning if you're joining us from Nepal
Thank you.
or Japan.
All right. Thanks, everyone.